Have you taken any steps in coming out with any kind of a procedure approved by the Parliament under 324(2)?
So it is not enough to say that for Parliament has been silent and inactive, etc. Know by now, all of us will know by now that
no court can issue a mandate to Parliament to make a law.
Either council would plead for that or the court will respond to it. I know that. But let me try to begin on a very smaller note if possible before you open up. I know the attorney shall not be seen to be taking a regressive stand on many of these very important issues.
That's right. That's strictly not adversarial. Public investigations.
I thought let me focus on some broad issues and then try to explain. The march of law from Vinit Narayan onwards, all of which arose in the context of perceived vacuums in law, statute law, or perceived vacuum defects in statute law cannot be invoked in the present case. 2. The prayers, looked at from any angle, ultimately require this court to alter the structure of Article 324(2), add to it, and in that process further requiring the court to take constitutional policy decisions as to what can be added to in Article 324(2) or what can be substituted therein. This the court will not do apart from being a constitutional policy issue to directly amount to a constitutional amendment. So these are the two broad responses to the petition. Now the attempt made before I read 324(2) and then what happened post-session and all that, I asked myself a question. If after the lengthy Constituent Assembly debates, if the Constituent Assembly decided on one particular course of action, it had all those models, the Canadian model and the other models. It had all the other models. And if the Parliament chose at that point of time that we will have a model like this, and broadly corresponding to certain other schemes of the provisions of the Constitution, it certainly had in mind the independence of the Election Commission. You can't attribute 324 that there is a complete absence of mind or application of mind to what may happen in future. That's why Ambedkar said even in future this may happen. Therefore, a futuristic vision as to what may happen was also in the mind of the Constituent Assembly debate. If all those aspects are in the mind of the Constituent Assembly debate, and ultimately they said the President as the authority will appoint, and in case suppose Article 74 was not there in the Constitution, the President will act on whose advice and Council of Ministers? The President will act with his own discretion. Now Bombay will come in today and say President cannot act with discretion. But there is a provision in the Constitution. So how will the President act as far as the President discharge of powers and functions? If Article 74 were not there, then a moot question would arise. The President is left rudderless as to how the President will discharge all these functions. Now, therefore, the argument today is the President, as if there is a vacuum, in 324(2), that the President does not have an appropriate authority who will ensure the independence of the Election Commission, and vesting this power in the executive cannot be treated to be that appropriate body. Therefore, there is a vacuum, and therefore the attempt is therefore to ask the court to imagine a vacuum and then take a position as to how that vacuum can be filled up.
Kindly come to Article 316. Kindly come to Article 316 of the
Yes.
Please read. That relates to the power to appoint members of the Union Public Service Commission.
Sorry. Appointment and term of office of members, that is the Public Service Commission. The chairman and other members of the Public Service Commission shall be appointed in the case of the Union Commission or a Joint Commission by the President, and in the case of a State Commission by the Governor of the State.
That's
Then the proviso says what will
how
be the
they can be
competition?
removed,
Respectively.
how they can be removed is also provided.
Correct.
That is as far as the UPSC.
Right.
Now you kindly also come to Article 148, dealing with CAG. We are just posing the question.
I'm extremely thankful for this suggestion. So what was running through my mind while looking at this 316, 148 and 324?
Yeah.
324 takes
The
care.
question
I'm sorry.
was,
I'll just read one part.
the question was to be
Yes.
148. There are other, safeguards.
Yes.
As far as the CAG is concerned, can be removed only in a manner it's provided.
Right.
As far as the appointment is concerned, it is by the president. There is no other safeguard. Why is it that when the Constituent Assembly debated it and then finally it was approved,
Yes.
they have put in the words subject to any law to be made? This will be the condition. The second question is, supposing 100 years from now,
Your Lordship, please.
you merrily carry on. Let's
Yes.
assume for a moment everything against you. That you have this executive form where the Council of Ministers under the rules of business, the government with the majority has its way, you pick up somebody, Council of Ministers under the rules of business, you pick up some officer
I understand.
and appoint. So this merrily continued. Now, is that not defeating the very, very wishes of the founding fathers you are laying store by when you say that all this was debated? So this is also debated, that you will have a law. Unlike in the case of CAG and in the case of Public Service Commission. They're just putting it here.
I quite see it. So if looking at a broad brush comparison of 148, 316, 324, coming back to 148 for a minute.
This says president shall be appointed by the president, nothing more. Doesn't contemplate any law.
I find that there's an important distinction between these three provisions. One is that the Constitutional Assembly and then the Constitution is adopted has added one important provision in 324(2), subject to a law that the Parliament may make in future. You don't have that in 148 and 300.
It is not there.
That's right.
That is the point.
That's right. I'll add what the Constitutional Assembly contemplated by that. It is not at a future point of time. Let me 324(2) and then come back to my propositions. Why is that a law made by Parliament was thought to be necessary in this context? There are a couple of reasons why it can be. We can speculate on that and try to zero in on what would have possibly the most important consideration why it would take. If I read it like this, the Election Commission shall consist of the chief election.
Have you taken any steps in coming out with any kind of a procedure approved by the Parliament under 324(2)? The procedure which has to be come out by under this mandate.
I'm so sorry.
You're not brought any. There's no mechanism with you. You follow your own mechanism.
Let me try to develop my. Shall consist of the Chief Election Commissioner and such number of other election commissioners, if any, as the President may from time to time fix. The authority to fix the number of commissioners was subject to the President's discretion or its wisdom. And the appointment of the Chief Election Commissioner, other election commissioners shall, subject to the provisions so and so, be made by the President. Therefore, the two components here. If both the components should have, suppose there was no contemplation of a law to be made by the Parliament, the President for all times to come would have been the only repository of authority to deal with the Election Commission. So if an argument has been developed because there is a parliamentary intervention contemplated, what is that Parliament would have intervened, and it could have only for the purpose of enhancing, if in the course of the exercise of power upon by the President, if there is a certain need to address that question, or even independent of any such occasion having arisen, Parliament looks at it. Like certain developments take place in the area of independence of the election commissioner, and events have taken place in the course of a democratic, polity. The Parliament will look at it independent of whether the President has acted wrongly, erroneously, or whatever it is, inefficiently. So there are two reasons why Parliament can intervene. So I asked myself the question: has any one of those reasons which could prompt the Parliament to intervene have occurred? So it is not enough to say, therefore, Parliament has been silent and inactive, etc., etc. Therefore, an mandamus will issue to ask the Parliament to apply its mind, or what would be the best course of action?
We are not being invited to issue a mandamus to Parliament, which we certainly will not accept. What we are actually asked to do is to sort of repeat a Vishaka, meaning that till you make a law, because we can't stop you from making a law. We can't say what we are going to say, or we are invited to say, should not be fingered with by you, by a law made by you.
Right.
That's a legislative power that nobody can take it away from you. Now, all of this is being traced, if you go to the Constitutional Assembly debate, it is being traced to the fundamental fundamental right of each citizen in connection with the right to exercise his franchise.
I quite see it.
Core of democracy. This is a fundamental right involved. Therefore, for the proper, efficient, effective exercise of that power, you need somebody who properly, fairly supervise. Now, if you find unfairness is writ large and it's not going to be stopped, our powers are sort of be invoked with the
I see it. I see that. Of course, all of us know by now. That
no court can issue a mandamus to Parliament to make a law.
either council would plead for that or the court will respond to it. I know that.